Justice Mamadou Jallow of the Bundunkakunda High Court on Wednesday ordered for Babukar Keita, alias Bob Keita, and one Mr. Jum to be taken to the Edward Francis Small Teaching Hospital and have their blood samples taken for the DNA. Now, Babukar Keita is standing trial on rape allegation, but has since denied any wrongdoing. Mafuji Sese has the rest of that in this report.
The trial was called on Wednesday afternoon. Kemben Tal, Deputy Director of Civil Litigation, announced his appearance for the state, while Attorney Lamin S. Kamara appeared for the accused person. State Counsel Kemben Tal informed the court that the last adjournment was made following court order for the DNA of the demised Mohammed to be taken and for the court to observe some housekeeping. He said two things flown from the ruling of the court, adding that all the modalities are in place for the immediate implementation of the court. Counsel Kembenta seeks the leave of the court for the accused persons to proceed to the Edward Francis Small Teaching Hospital for the collection of a sample at the end of the proceeding. He told the crowded court that the DNA evidence will need to be submitted by the state by expert evidence record intimated at the last hearing. He said on Friday, July 8, 2022, the object of the DNA testing, Mohammed, passed away in the Senegalese capital, Dakar, but that the DNA samples have been collected before his demise. Replying on points of law, the defense counsel lawyer Lamin S. Kamara objected to the application, arguing that it has no basis in law, even though the court ordered that the accused person, Babukar Keita, Mohammed, the child, and one Pamodu Jom should be subjected themselves to the DNA, having their blood samples extracted on July 7, 2022. Attorney Kamara informed the court that when the ruling was read, Counsel Jallow informed the court that the accused person is desirous of appealing against the order of the court and therefore applied the order of the ruling, which the court promised to avail the right to appeal against. The ruling is the constitutional right of the accused person, and that right can only be competently exercised by the accused persons if he is availed the copy of the ruling of the court. The appeal will only be rendered competent if the judgment order or ruling is attached to the notice of the appeal, a part of the ruling, a stay of the execution of the ruling of July for the court to determine. Pending the determination of stay of the ruling of July 7th, the state cannot proceed with what they determined to do. Counsel Kamara further went on to say the court needs to avail the copy of the ruling to the accused person, and therefore the court cannot grant the application today, which can only be confirmed or done if the ruling is served on the accused person. Lawyer Kamara told the court that the state application is seeking to foster the submission that DNA has been collected on Mohammed before he passed on the 8th of July 2022, adding that this submission is worrying and disturbing, to say the least, because it can only mean that the blood sample was allegedly extracted from a child in coma, and the blood sample were collected before the court order and in the presence of no interested person, counsel, and the accused person, and that is unacceptable to the accused person because it's against all principles of fair hearing and transparency. Kamara said if the blood extraction of the child is to be subjected to DNA examination, it must be done in a manner that inspires confidence and transparency and does not enclose doors. He stresses that compliance with the order of the court means extracting blood samples from the three parties, Pamodu Jom, Mohammed the child, and Babukar Keita, after the ruling or after it was ordered and in the presence of all interested parties, in order assurance of the show. He urged the court to refuse the application and ordered that the defendant is served with the ruling immediately for the defense to file an appeal and a stay of proceeding before the court within 2 days. Delivering the ruling, Justice Jallow adopted the submission of the state counsel. Justice Jallow stressed that the stay of proceeding will not be granted if it is intended to waste court time. He ordered that both Pa Modu Jom and Babukar Keita's blood samples be taken at the Edward Francis Small Hospital. Justice Jallow declared that he is satisfied with the blood samples collected on Mohammed the child as long as it's from a hospital. The matter continues on July 18, 2022 at 11 a.m. in the morning. For Eyeafrica News, I am Mafuji Sise.